This is Michael Popok. You're on the new Legal AF YouTube channel, and I'm at the intersection. We got a new ruling by the D.C. Court of Appeals that could put back at the United States Supreme Court whether charges brought against 1,400 insurrectionists during Jan 6 are going to survive. Yes, the United States Supreme Court is going to stick their big fat noses again into whether a certain trespass statute used successfully by the Department of Justice to make sure that everybody that decided to attack the Capitol and try to burn down democracy got one charge or another, that's now potentially imperiled. Yes, the headline is that the D.C. Court of Appeals, in a 2-1 decision, decided to affirm a trespass charge against a former New Mexico commissioner and sort of an objector to all things federal government, this guy Couey Griffin. Couey Griffin, who was removed from his New Mexico commission seat because he was found to be an insurrectionist for being there and walking through a Secret Service protective line that was set up to protect Mike Pence, who happens to be the Vice President of the United States at the time. When he wouldn't leave, he was charged with trespass and violating the directions of the Secret Service. Those laws have been in place since 1971 and were put in place to strengthen the ability to protect the Secret Service and therefore protect their protectees, people like JFK and RFK, who were both assassinated. These were the rules that were put in place in order to have crimes on the books to address people who wanted to breach a Secret Service line. And that's what Couey Griffith did. Now, Couey Griffith should have known he was going to lose here at the United States Supreme Court because he already lost once before. He was removed under the insurrection clause of the 14th Amendment from his seat on the New Mexico Commission. He was a commissioner because of his involvement in Jan 6 and being charged and convicted of federal offense of crossing a Secret Service line. That's the trespass that was up for grabs in this particular case. And he was removed by exercise of that same 14th Amendment insurrection clause that Donald Trump was taken off the ballot in Colorado until the United States Supreme Court said, put him back on. But with Couey Griffith, they refused his appeal, meaning he was permanently removed as an insurrectionist from serving on that county board. Now he was trying to get out from under the actual felony conviction, and it wouldn't just have impacted him, but another 1,400 people all charged with trespass. See, everybody that attacked the Capitol, whether they picked up a police baton or bear spray and tried to kill or maim police, or they stepped through and disregarded police instructions, or they broke into the Capitol, or they crossed Secret Service lines, everybody was given some sort of charge that fit the crime. And for this guy and 1,400 others, a lot of this makeup or mop-up duty by the Department of Justice was to charge them with criminal trespass, which, could be sentenced for a period of time up to a year in jail. But Couey, who lost his commission seat, didn't like that. So he tried to unlock the door for 1,400 people and let them all out of the prison, right, and get all of their records expunged. And the D.C. Circuit, 3-judge panel, because just to remind everybody, whenever you have an appeal at the federal court, your first stop on the appeal is a 3-judge panel, randomly selected from the full amount of appellate judges for that particular circuit. Every federal court reports to a circuit, one circuit. That circuit can have anywhere between, it depends, 8 and 15 or 18 judges. 3 get randomly selected, and they make their ruling. Here, it was 2-1. That's all you need is a majority rule. The 2 in favor of keeping the trespass on the books as a properly charged crime for these 1,400 people, including Mr. Griffith, included Judge Pillard, who was an Obama appointee, and Judge Rogers, a Clinton appointee. But there's a strong dissent by Judge Katsas, who's often on the opposite side of the Biden administration, a Trump appointee. And Judge Katsas said, well, this new law, it's been around since 1971. This law could capture a lot of innocent conduct within its net. It's too overly broad. It's not putting people on proper notice about what is a crime. And he gave all these ridiculous examples. Like you're thirsty and you're looking for a drink at a bar, and there's a protective line set up by the Secret Service. And you don't know the first lady's in there, but you open up the little line because you want to get a drink at the bar. And now you've been arrested for trespass. Oh my God. And Judge Katz says, and I'll give you another example. What if you were doing a shortcut on Jan 5 on, by the way, has he ever been to the Capitol? I know he works in the Capitol. So he's doing a shortcut through the Capitol, which is barricaded now with protective tape around it, protective zones around it. And in order to get to his apartment, he cuts through, the protective line set up by the Secret Service. And because he's lawfully carrying a gun at that moment, he's now looking at 10 years. You know what? That probably is good. You should be more careful when you're traipsing your way and trespassing your way through the United States Capitol during a time of a major event like an inauguration or the Jan 6 certification, which I didn't even know. Can I just have an aside for a minute? I know we can't, it's been indelibly tattooed onto our brain, Jan 6th, but put it in a comment. Did anybody focus ever in their life and have it as a red letter day on their calendar, Jan 6th? As the day the electoral certificates were counted, it was like a nothing day. It was like, hey, we got a winner in November, or maybe if you're Bush versus Gore, it comes much later than that, after 40 or 50 days. But Jan 6th was not a thing. Now it's a thing, and so Katz's little love note to Trump is now going to end up, you can see it, going to get called up to the United States Supreme Court. Although they did reject a Griffin appeal before, as I said earlier, when he said, I want to be a commissioner. And they said, no, you're an insurrectionist. Appeal denied. So we'll have to see what they're going to do. As much as the Supreme Court right wing is taking special delight in reshaping the presidency and a Department of Justice's role in our criminal justice system, I don't think they want to strip away 1,400 counts for trespass. They already monkeyed around with one of the highest charges that were used, the obstruction of an official proceeding in the Fisher case this past summer, which got little notice, but we do talk a lot about it on Legal AF. In the Fisher decision, the Supreme Court said, yeah, no, you can't use this 2001 law, which wasn't formulated for this, to claim that the insurrectionists who were trying to burn down our democracy were obstructing the official proceeding of counting the votes, although that's exactly what they were doing, or certifying the election. That's exactly what they were doing, because we don't like the way that statute maps onto the conduct. So goodbye, unless you can find somebody using false evidence or fake ballots or fake certificates. I wonder who they're talking to there. And so the Fisher decision already put on life support a number of charges against a handful, 20 or 30 different insurrectionists. Fortunately, they were all charged with some other heinous crimes. They all did terrible, terrible things. But I don't think they want to do it again. But as of right now, in wet cement, drying quickly, we can say that the D.C. Circuit Court of Appeals in a 2-1 decision has affirmed the prosecution's use and the convictions of people for criminal trespass or crossing Secret Service protective lines as part of Jan 6 and into the future, subject to a United States Supreme Court, maybe in 2025, maybe after 2025, taking it up on appeal. We'll follow it all. You're already here on Legal AF, the new YouTube channel. Take a moment. Early voting is open. Free subscribe. Hit the button. Help us get to 300,000 by Halloween. We're going to get there with your help. And you'll find what I hope you'll find is this kind of really informative information, commentary, and analysis at the intersection of law and politics like no other on YouTube. That's what 50 million people a month, I think, already know. Between our hot takes, our podcast, at the intersection, our new content here and playlists here on Legal AF and every place else. And I welcome you. I'm Michael Popok. I welcome you to our channel and thank you for being part of our building a new pro-democracy channel in connection and relationship with the Midas Touch Network. So until my next content, I'm Michael Popok, and I am reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.